There is perhaps no doubt that our post-colonial liberal democratic system is plagued by the British legacy of the Unlawful Activities Prevention Act. Historically, anyone speaking out against the colonizers' control would be imprisoned as a result of this law. But even after we agreed to be a democracy that promotes principles of liberty and tolerance, and even after 75 years of independence from our colonial overlords, our state continues to place priority on laws that suppress any dissenting opinions. Students, civil rights activists, and media personalities gathered at the Press Club of India to express solidarity with former JNU student Omar Khalid, who completed 1,000 days behind bars after being arrested in a 2020 Delhi riots case. Charged with the Unlawful Activities Prevention Act, Khalid has spent day after day in jail, as have several other rights activists, lawyers, and others incarcerated for their dissenting views. One such individual, Imran Ahmad, was incarcerated due to his alleged involvement in the Bangalore riots of 2020. However, his bail plea, centering around the famous dicta of Justice Krishna Iyer that bail is the rule and jail is an exception, stands quashed by the Karnataka High Court on grounds of public safety, collective interest of society over individual liberty. This judgment by the division bench of Justice Krishna Dikshit and Justice Pradeep Singh Hirur shows how bail-related decisions in UAPA have been inconsistently used by judges. But before that, let's look at how the law developed. On 18 January 1963, Article 19(2) of the Constitution that allows the government to pose reasonable restrictions on the freedom of speech and expression was amended for the last and final time, and the words sovereignty and integrity of India were inserted in it. The Constitution's 16th Amendment Bill 1963 was informally referred to as the Anti-Succession Bill and was designed to prevent local political leaders in different regions within India from using the electoral process to peacefully propagate succession from the Union. However, the plan for the amendment had started earlier, in 1961, when a National Integration Committee had been set up under the leadership of C.P. Ramaswamy Iyer. The committee had recommended that peaceful advocacy in favor of succession be made a criminal offence. This applied not only to any form of expression under Article 19, but also to the other parts of Article 19, including peaceful protest and the right to form peaceful associations. The 16th Amendment hence paved the way for the passage of the Unlawful Acts Prevention Bill. The bill was tabled twice in the Parliament during the 3rd Lok Sabha between 1965 to 1967, and in both cases there were widespread protests before it was finally passed into an act as UAPA in the 4th Lok Sabha in 1967. The UAP bill sought to empower the central executive to ban organizations by declaring unlawful a range of activities which encourage or aid persons in unlawful activities or who undertake unlawful activities habitually. The voices of the opposition to UAPB argued specifically against two parts of the UAPA. The first was that the burden of proof was on the association which was banned, and the second was the tribunal system of appeal for the ban. The tribunal, as defined in the 1967 Act, referred to a tribunal constituted by the central government, also known as the Unlawful Activities Prevention Tribunal. It consisted of one person appointed by the central government who was a judge of the High Court. The tribunal had same powers as vested in a civil court under the Code of Civil Procedure 1908. Despite that, the Act was passed allowing the UAPA to impose all India bans on alleged terrorist organizations. Based on the categories unlawful activity and unlawful association, the UAPA originally permitted the government's banning of associations and organizations. Unlawful activity was defined as any activity that intends or supports any claim to bring about cession of a part of India or which incites any individual or group to bring about succession which questions the territorial integrity of India. Unlawful association meant that if the central government is of the opinion that any association is or has become unlawful, an unlawful association, it may by notification in the official gazette declare any such association to be unlawful without any need for disclosure. Now let us briefly talk about a similar act. In 1985, after the assassination of Indira Gandhi, the Indian Parliament passed the Terrorist and Disruptive Activities Prevention Act, TADA, intended to crack down on the pro-Khalistan movement in Punjab. TADA was the first act aimed to define terrorist activity as any action with intent to overthrow the government, to strike terror in the heart of people, or to alienate a section of people through the use of weapons of hazardous nature, which could cause injury, death, damage to the property, destruction of supplies. TADA gave law enforcement authorities broad powers. No need to produce a detainee in front of a judicial magistrate for 48 hours, detention without charges up to 1 year, confessions made to police officers were admissible as evidence, in-camera proceedings were permitted. Between 1987 and 1994, 75,000 people had been charged under TADA. 35% of the cases came to trial. 1.8% of the accused were convicted. In 1995, it was repealed by the Narasimha Rao government because of the anger against it, but it was soon replaced by a new law with similar provisions. After the 9/11 attacks and the Indian Parliament attack of 2001, the legislature hurriedly passed an ordinance called the Prevention of Terrorism Ordinance. The next year, it was ratified into Prevention of Terrorism Act, POTA. POTA brought many of the provisions of TADA, including the special courts, the in-camera proceedings, the admissibility of police confessions, this time without a lawyer present, and added a few new components like criminalizing the membership of a banned organization and removing the need to make an FIR or even a remand report available to the accused for up to 180 days. POTA was repealed in September 2004. However, this did not mark the end of the act. In 2004, UAPA was amended to include certain provisions from POTA. The first and most significant was that the amendment increased the definition of unlawful activity to any action which disclaims, questions, disrupts, or intends to disrupt the sovereignty and territorial integrity of India, and which causes or intends to cause disaffection against India. The second new crime included in the amended 2004 UAPA was Terrorist Act. UAPA now included the exact same definition of terrorist act as TADA or POTA. The punishments for these new offences were extended to 7 years, up to life imprisonment and even death penalty. So this now meant that terrorist and unlawful activities with their new definitions led to a changed burden of proof and tribunals under the UAPA framework. Prior to the 2019 amendment, the UAPA provided for the notification of organizations as terrorist organizations and listed membership in a terrorist organization as well as financing of such organizations as punishable offences. With the amended provision, UAPA now allows the government broad powers when it comes to designating an association and even an individual as a terrorist. So now broadly under the UAPA, someone can be designated a terrorist and be kept almost indefinitely in prison while investigation goes on. The use of the law to imprison anyone the government chooses is what makes UAPA so problematic. The rights of a person against whom the case is brought are violated when special prosecution techniques are applied. From Bhima Koregaon to riots in Bangalore to the riots in Northeast Delhi, the law has been used increasingly over the years. What is surprising is the conviction rate under the law. As per the Home Ministry's 2020 report, only 212 of the 24,134 persons detained under the UAPA were found guilty between 2016 and 2020. Most of those detained under the anti-terror legislation remained behind bars for years, even before a trial. Those detained under the UAPA include authors, poets, teachers, lawyers, activists, trade unionists, doctors, and even regular citizens who were targeted for speaking out against state repression, including extrajudicial killings and defending the rights of India's minority communities, including Muslims, Dalits, and Adivasis.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.